Good morning, good afternoon, or good evening from wherever you're watching or listening. My name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information plenty of bad folks would rather you not have. Today we're going to be providing another installation into our Anti-Federalist Papers series going on number 17. So if you haven't gone back and watched 1 through 16, I would highly encourage you to do so because understanding the Anti-Federalist Papers in addition to the Federalist Papers is going to provide you a very advantageous supplementary, well-rounded understanding of the U.S. Constitution. And understanding the U.S. Constitution is absolutely imperative if you intend to combat any sort of lawfare waged against you, your loved ones, or your hard-earned property. So let's go ahead and jump on over to the Anti-Federalist Papers. There are multiple institutions from which you can get a paper and digital copy of the Anti-Federalist Papers. Go ahead and get both formats just in case you can't access one or the other for whatever reason. While you're out there looking, go ahead and pick up a paper and digital copy of the Federalist Papers as well, so that way you can join us in comparing and contrasting the arguments for and against, excuse me, ratifying the U.S. Constitution. Excellent. So number 17 is titled, Federalist Power Will Ultimately Subvert State Authority. Man, doesn't that ring home? Ring true to the heart. Okay. So they say this. The, quote, necessary and proper clause has from the beginning been a thorn in the side of those seeking to reduce federal power, but its attack by Brutus served to call attention to it, leaving a paper. This might be an introduction rather than a direct quote from the Anti-Federalist who wrote this. We'll see. We'll read it as if it's the person who wrote the Anti-Federalist paper number 16. This may be an additional explanation of what's actually said down here, but I digress. So let's restart. The, quote, necessary and proper clause has from the beginning been a thorn in the side of those seeking to reduce federal power, but its attack by Brutus served to call attention to it, leaving a paper trail of intent verifying its purpose was not to give Congress anything the Constitution forgot, but rather to show two additional tests for any legislation Congress should attempt. To it, that the intended actions would be both necessary and proper. I don't know why I said it so quickly. And proper to executing powers given under clauses 1 through 17 of Article 1, Section 8. This is the famous Brutus. Okay, so that was an introduction. That was not part of the Anti-Federalist paper. That is an explanation. Okay, so this is the actual Anti-Federalist paper. This new government is to possess absolute and uncontrollable powers, legislative, executive, and judicial, with respect to every object to which it extends, for by the last clause of Section 8, Article 1st, it is declared that the Congress shall have power, quote, to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by its Constitution in the government of the United States or in any department or office thereof. And by the 6th article it is declared that this Constitution and the laws of the United States, which shall be made in pursuance thereof, and the treaties made, or which shall be made under the authority of the United States, shall be the supreme law of a land, and the judges in every state shall be bound thereby, anything in the Constitution or law of any state to the contrary, notwithstanding. It appears from these articles that there is no need of any intervention of the state governments between the Congress and the people to execute any one power vested in the general government, and that the Constitution and laws of every state are nullified and declared void so far as they are or shall be inconsistent with this Constitution, or the laws made in pursuance of it, or with treaties made under the authority of the United States. Wow, does that not just speak directly to what we're witnessing today and have been witnessing for a very long time. It's almost like the founders knew exactly what was going to happen and explained exactly and explicitly why the U.S. Constitution was going to lead to this inevitable tyranny. But here we are. And the really sad part is they actually won the argument. The convention did not yield the requisite number of delegates voting in favor to ratify the U.S. Constitution for it to be ratified. We've gone over it 12.5 times. The Articles of the Confederation required unanimous consent by all of the states to amend, let alone completely replace, the Articles of the Confederation. If the U.S. Constitution was to be implemented in the way it was, the states would have first had to secede from the Articles of the Confederation, set new terms for erecting a new government, and then the two-thirds rule, or whatever other rule these activist historians want to conjure up to say, yeah, the Constitution, the U.S. Constitution was actually ratified legitimately. No, it was never ratified. It was imposed. It was implemented. It was enforced. Never ratified. So the Anti-Federalists actually won the argument, but they did not stick to their, I guess it would be stick to their guns, because the way the U.S. Constitution has been applied is with the force of arms rather than the force of diplomacy and civility and proper governance, as even Alexander Hamilton recognized. Back to the Anti-Federalist Papers. The government then, so far as it extends, is a complete one, and not a confederation. It is as much one complete government as that of New York or Massachusetts, has as absolute and perfect powers to make and execute all laws, to appoint officers, institute courts, declare offenses, and annex penalties with respect to every object to which it extends, as any other in the world. So far, therefore, as its powers reach, all ideas of confederation are given up and lost. It is true this government is limited to certain objects, or to speak more properly, some small degree of power is still left to the states, but a little attention to the powers vested in the general government will convince every candid man that if it is capable of being executed, all that is reserved for the individual states must very soon be annihilated, except so far as they are barely necessary to the organization of the general government. The powers of the general legislature extend to every case that is of the least importance. There is nothing valuable to human nature, nothing dear to freemen, but what is within its power. It has the authority to make laws which will affect the lives, the liberty, and property of every man in the United States. Nor can the Constitution or laws of any state in any way prevent or impede the full and complete execution of every power given. The legislative power is competent to lay taxes, duties, imposts, and excises. There is no limitation to this power, unless it be said that the clause which directs the use to which those taxes and duties shall be applied may be said to be a limitation. Now that part's not exactly true. I think it's Article 1, Section 10? Section 10 or Section 9. It says directly that, or it's in Article 1. I'm fairly confident of that. It does limit taxation and the power of the federal government to tax certain sources. It says overtly there is never to be a capitation tax. A capitation tax is what we consider today to be an income tax. Even with amendment to the U.S. Constitution, it would have to overtly say the federal government can now levy a capitation tax, which at that point you would be in total contradiction to the founders' whole purpose. You have to be represented in every single tax that you pay. Otherwise, it's an unrepresentative tax and therefore abusive and not a justly exercised power of governance. I mean, that's the whole foundation of the American Revolution. But I digress. The powers of the general legislature extend to every case that is of the least importance. There is nothing valuable to human nature. We've already read over this, but we're reading it. Nothing valuable to human nature, nothing dear to freemen, but what is within its power. It has the authority to make laws which will affect the lives, the liberty, and property of every man in the United States, nor can the Constitution or laws of any state in any way prevent or impede the full and complete execution of every power given. I wanted to reread that because there are so many valuable, important quotes in the Anti-Federalist Papers, but that one just speaks so directly to what we are experiencing as states experiencing today. And they knew it would happen. In 1787, in 1788, before the U.S. Constitution was even implemented, they knew it was going to happen. There is no excuse to say, oh, well, golly gee, this is completely unforeseeable. How could we have known any better? You were told better. Well, not you personally, but the people who wrote this government, that many people fervently, emotionally, viscerally support, the very people who were involved in debating the document which forms the government you support, predicted it would bring about tyranny before it was even implemented. It is, by every measure, a faulty, inefficient, ineffective document. And it establishes an inevitable tyranny of a government. And the founders knew that. The framers of it knew that. Because this right here, the Anti-Federalist Papers, gets rid of any sort of plausible deniability. They were told, they were warned, and they didn't heed the patterns of history. The legislative power is competent to lay taxes, duties, imposts, and excises. There is no limitation to this power. Not true. There is a stated limitation, unless it be said that the clause which directs the use to which those taxes and duties shall be applied may be said to be a limitation. That's also a limitation, but there's also a direct limitation, no capitation tax. But this is no restriction of the power at all, for by this clause they are to be applied to pay the debts and provide for the common defense and general welfare of the United States. But the legislature have authority to contract debts at their discretion. Yep. Who would like to talk about that $37 trillion debt? They are the sole judges of what is necessary to provide for the common defense, and they only are to determine what is for the general welfare. Man, does that not hit directly home? How many times have we heard the Supreme Court, oh, well, necessary and proper clause, necessary and proper clause. Well, it says in the Constitution that you actually can't do this, federal government, but hey, it's necessary and proper, and then the necessary and proper clause. The people knew, the framers knew, they were told, they were warned, and they didn't listen. It is a faulty document, faulty government. Please, for these people's sake, for their veneration and their vindication, stop supporting this document, because even they knew, before it was implemented, the kind of garbage we experience today was going to inevitably happen. This power, therefore, is neither more nor less than a power to lay and collect taxes, imposts, and excises at their pleasure. Not only the power to lay taxes unlimited as to the amount they may require, but it is perfect and absolute to raise. To raise them in any mode, there's a typo, raise them in any mode they please. No state legislature or any power in the state governments have any more to do in carrying this into effect than the authority of one state has to do with that of another. In the business, therefore, of laying and collecting taxes, the idea of confederation is totally lost, and that of one entire republic is embraced. It is proper here to remark that the authority to lay and collect taxes is the most important of any power that can be granted. Now, that one's true. It connects with it almost all other powers, or at least will, in process of time, draw others after it. Yeah. Because once they collect a purse, they can buy as many mercenaries as they need to impose any other illegitimate powers and actions of government. It is the great mean of protection, security, and defense in a good government with the great engine of oppression and tyranny in a bad one. This cannot fail of being the case, if we consider the contracted limits which are set by this Constitution to the state governments on this article of raising money. No state can emit paper money, lay any duties or imposts on imports or exports, but by consent of the Congress, and then the net produce shall be for the benefit of the United States. The only means, therefore, left for any state to support its government and discharge its debts is by direct taxation. And the United States have also power to lay and collect taxes in any way they please. Everyone who has thought on the subject must be convinced that but small sums of money can be collected in any country by direct tax. When the federal government begins to exercise the right of taxation in all its parts, the legislatures of the several states will find it impossible to raise monies to support their governments. Without money, they cannot be supported. Ding, ding, ding. Go ahead and highlight that. That's exactly what we were just talking about. Without money, they cannot be supported. And they must dwindle away, and as before observed, their powers be absorbed in that of the general government. Just like every other government, there has to be a source of revenue. There has to be a source of value. And if you give a government that power to collect or to ascertain, to erect sources of revenue, well, once they collect that revenue, they can buy as many guns, as many tanks, as many boots as they need to impose whatever actions or ambitions they have. It might be here shown that the power in the federal legislature to raise and support armies at pleasure, as well in peace as in war, and their control over the militia, tend not only to a consolidation of the government, but the destruction of liberty. Whoa. Big statement there. Also rings true. What do we hear most often when we hear of groups saying they're going to civilly protest. They're going to civilly disobey, comply, or be another Waco, Texas, be another Ruby Ridge. It is comply or die. That's not a government, as even Hamilton said. It's just tyranny. That's just anarchy, dressed in some pretty robe. I shall not, however, dwell upon these, as a few observations upon the judicial power of this government, in addition to the preceding, will fully evince the truth of the position. The judicial power of the United States is to be vested in a Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. The powers of these courts are very extensive. Their jurisdiction comprehends all civil causes except such as arise between citizens of the same state, and it extends to all cases in law and equity arising under the Constitution. One inferior court must be established, I presume, in each state at least, with the necessary executive officers appendant thereto. It is easy to see that in the common course of things, these courts will eclipse the dignity and take away from the respectability of the state courts. Who do we appeal to? Our state Supreme Courts? No, the U.S. Supreme Court. When in actuality, the framers would say, you know what? Yeah, the rulings from the U.S. Supreme Court can absolutely be appealed to the state Supreme Courts, because the states form the Union, not vice versa. The Union serves the states, not vice versa. And if the ultimate court being appealed to is not from the state, then the ultimate authority does not belong to the states. It belongs to the general government, which is an idea contrary to the framers' intent. These courts will be, in themselves, totally independent of the states, deriving their authority from the United States. Oh, doesn't that sound true? Doesn't that ring home? And receiving from them fixed salaries. And in the course of human events, it is to be expected that they will that they will swallow up all the powers of the courts in the respective states. Golly, it is just one right after the other, quotes that are directly applicable today. How far the clause in the 8th section of the first article may operate to do away with all idea of confederated states and to effect an entire consolidation of the whole into one general government, it is impossible to say. Article 1, Section 8, by the way, details the powers of the legislature of Congress. The powers given by this article are very general and comprehensive, and it may receive a construction to justify the passing almost any law. Yeah. A power to make all laws which shall be necessary and proper for carrying into execution all powers vested by the Constitution in the government of the United States, or any department or officer thereof, is a power very comprehensive, indefinite, and may, for aught I know, be exercised in such manner as entirely to abolish the state legislatures. Golly. Don't be embarrassed, because I was one of them. We've been taught to only focus on federal elections, not even about Congress, exclusively about the U.S. president. Tell me how this statement here is not true today. How this prophecy, perfect prediction, stated before the U.S. Constitution was even implemented, how it is any way falling short or incorrect as to our situation today. Do you know who your state legislator is? Do you have a bicameral legislature? How many senators? What are their names? What are their office numbers? What are their phone numbers and emails? These gentlemen, those composing your state legislatures, your state governments, by the Constitution, both U.S. and state, have significantly more authority, significantly more involvement in your daily operations than any officer of the federal government. Focus on your state legislatures. Focus on your state governments, because that's how the framers intended it. Suppose the legislature of a state should pass a law to raise money to support their government and pay the state debt. May the Congress repeal this law, because it may prevent the collection of a tax which they may think proper and necessary to lay to provide for the general welfare of the United States. Golly. This is a really good Anti-Federalist paper. For all laws made in pursuance of this Constitution are the supreme law of a land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of the different states the contrary notwithstanding. By such a law, the government of a particular state might be overturned at one stroke and thereby deprived of every means of its support. Again, all said, all predicted, all prophesied before the U.S. Constitution was ever implemented. So this is not a, well, hindsight is 2020 argument. No. This is what they were saying when the document was being debated. The people who were in favor of it knew. They were told. They were warned. And they refused to listen. Because these people's prophecies, their predictions came true, what argument do you have to convince me that we shouldn't listen and apply these principles rather than those of the people who got the predictions completely incorrect? Those being the people advocating for the U.S. Constitution's ratification. Why should we listen to them when these people accurately, almost perfectly, have predicted the outcomes of the U.S. Constitution? Why don't we listen to them? Because they got it right. Almost perfectly. It is not meant, by stating this case, to insinuate that the Constitution would warrant a law of this kind, or unnecessary to alarm the fears of the people by suggesting that the federal legislature would be more likely to pass the limits assigned to them by the Constitution than that of an individual state, further than they are less responsible to the people. But what is meant is that the legislature of the United States are vested with the great and uncontrollable powers of laying and collecting taxes, duties, imposts, and excises, of regulating trade, raising and supporting armies, organizing, arming, and disciplining the militia, instituting courts, and other general powers, and are by this clause invested with the power of making all laws, proper and necessary, for carrying all these into execution, and that they may so exercise this power as entirely to annihilate all the state governments and reduce this country to one single government. Go ahead and highlight that. Where'd it go? Where'd it go? There it is. Go ahead and highlight that whole sentence. But what is meant is, start there, highlight that whole paragraph. It's a run-on sentence, but every bit of that is crucial. And if they may do it, it is pretty certain they will, for it will be found that the power retained by individual states, small as it is, will be a clog upon the wheels of the government of the United States. The latter, therefore, will be naturally inclined to remove it out of the way. Besides, it is a truth confirmed by the unerring experience of ages that every man and every body of men invested with power are ever disposed to increase it and to acquire a superiority over everything that stands in their way. This disposition, which is implanted in human nature, will operate in the federal legislature to lessen and ultimately to subvert the state authority, and having such advantages will most certainly succeed if the federal government succeeds at all. Highlight that. It's just human nature. If men were angels, it must be very evident then that what this Constitution wants, of being a complete consolidation of the several parts of the Union into one complete government, possessed of perfect legislative, judicial, and executive powers to all intents and purposes, it will necessarily acquire in its exercise and operation. Signed, Brutus. Excellent. So if you have any questions at all, what Mr. Brutus was saying in number 17, if you have any questions about what was said in the papers 1 through 16, or maybe there's a topic you'd like me to cover in a future lecture, please post them down in the comments, because the entire purpose of the Calhoun School of Law is to provide you with the necessary skills and information, such as this, to combat the ever-growing hostile lawfare state looking to conduct lawfare on you, your loved ones, or your hard-earned property. So please, if you have any questions at all, post them down in the comments. Excellent. So my name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. I hope you enjoyed this lecture, and if not, while you're down in the comments, go ahead and let me know how I can do better so I can best serve that purpose of helping you. I hope y'all have a wonderful day, and I'm not sure what the topic for next lecture is going to be, but I'll do my best to make it as informative and entertaining as this one, if not more so. regardless of the topic of the next lecture. Until I see y'all then, I bid you all farewell.